Welcome back. Today we are undertaking a really detailed examination of the source material we've been given, and it focuses on one of the most legally complex and just tragically violent cases to come out of Florida in the last decade.
It's a very difficult subject, and it's absolutely crucial that we approach this material with the deep seriousness it requires.
I agree.
The facts of the crime itself are just horrific, marked by, well, extreme violence and a complete disregard for human life.
And what really sets this case apart, what our sources illuminate so thoroughly, is the sheer youth involved.
Yes. The victim, Seath Jackson, was only 15. And almost all of the perpetrators were teenagers themselves.
That is the core difficulty here, isn't it? We're dealing with teenagers and young adults who committed an act of, well, unbelievable malice. So our analysis today isn't just about tracing the timeline of events. It's really about dissecting the massive legal fallout.
Exactly. This case became a kind of proving ground for huge constitutional issues.
Issues related to juvenile sentencing and also the tumultuous, constantly evolving standards of capital punishment, particularly in Florida.
The initial tragedy is just so stark. Seath Jackson, born in February of 1996, was killed on April 17, 2011.
And the method was it was a trap.
It was. He was lured to a house under completely false pretenses, attacked by a group of 5 people, shot, and then, in a calculated attempt to destroy evidence, his body was burned.
And the remains were dumped in a local rock quarry.
A horrifying sequence of events.
And the complexity begins immediately when you look at the lineup of individuals who were charged.
Right.
We're looking at 6 people in total. 5 were the youths who actually carried out the crime. Their ages ranged from 15 to 20.
And that group included Michael Sheen Bargo Jr., who was 18. He's identified as the ringleader and ultimately the shooter.
Then you have the 6th person, the 37-year-old accessory, James Havens. He's the one who helped dispose of the remains.
So the sheer number of participants, and their very different legal standings, from minor to adult, from principal actor to accessory, it just sets the stage for this incredibly convoluted legal process that went on for more than a decade.
Precisely. The Marion County courts had to juggle juvenile law considerations, they had to handle adult murder trials for teenagers, and ultimately they had to pursue the death penalty for Bargo.
And all of this was happening while the U.S. Supreme Court was rapidly redefining the constitutional limits on how the justice system is supposed to treat juvenile offenders.
It created this incredibly volatile legal environment where stability was, well, it's basically impossible.
Yeah.
Okay, let's try to unpack the path that led to this tragedy.
Yeah.
We should focus first on the relationship dynamics and the escalating hostility that turned what was essentially a teenage breakup into a full-blown murder plot.
It started, as so many of these youth-related tragedies do, with what you could call typical high school emotional turmoil.
Right.
The core of it was the bitter breakup between Seath Jackson and his 15-year-old ex-girlfriend, Amber Wright. Their relationship, according to the sources, lasted from about December 2010 to March 2011.
And the end was not amicable.
Not at all.
And almost immediately after that breakup, Amber Wright began dating 18-year-old Michael Shane Bargo Jr.
Right. Bargo, being 3 years older than Jackson, quickly seemed to assume this role of the protective, or perhaps the territorial new boyfriend.
He became the undisputed ringleader in what was to come, the primary aggressor and, as we said, the shooter.
And Bargo's motivation, according to the sources we have, was rooted in a belief that was fundamentally incorrect.
What was that?
He was driven by this misguided sense of protection or maybe revenge because he wrongly believed that Seath Jackson had physically abused Amber Wright during their relationship.
And that wasn't true.
The sources indicate it was a fabricated justification, and it seems to have been the lever he used to escalate the conflict and perhaps to draw other people in.
That misinformed motive is such a tragic element. It gave Bargo this perceived moral superiority in his own mind, a way to justify lethal violence. And if we look at Jackson's side of the dynamic, the sources highlight how this conflict was playing out very publicly.
Yes, on social media. His posts from early March 2011 really reflect this volatile situation.
So it wasn't private.
Not at all. Initially, Jackson's posts show some lingering affection for Wright, but that soured very quickly. It transitioned into these public expressions of anger.
And the sources note he was suggestively accusing her of two-timing him.
Correct. So the conflict was not only heated, but it was being amplified across these digital platforms, where slights can feel magnified, and for a teenager, reputation feels paramount.
The sources confirm this wasn't a sudden, spontaneous act of violence, this digital conflict. It spilled over into real-world threats for about 2 or 3 weeks leading up to April 17th.
Absolutely. The tension moved past just keyboard conflict. It became direct, face-to-face confrontations between Bargo and Jackson. This period of escalation is key to establishing the element of premeditation that prosecutors used later.
And there is one specific chilling detail that's cited in the sources.
Yes.
During a quarrel at Jackson's house, Bargo purportedly issued a direct and lethal threat. He told Jackson he would have a bullet with your name on it.
When a threat like that is made weeks in advance and then it's actually executed, the legal system rightly views that as clear evidence of premeditation.
No question.
But what's fascinating and deeply disturbing is that Bargo wasn't acting alone, and not all the co-conspirators even shared his exact motive.
Right. We have to consider Kyle Hooper.
Amber Wright's 16-year-old brother.
Yeah.
He was involved in the planning and the execution.
And Hooper's involvement, it was rooted in a distinct separate grievance. It really underscores the layered motives here.
It does. He'd actually been a close friend of Jackson's.
So what turned him?
He turned against him not just because of his sister's relationship drama, but because of a very specific incident. He had caught Jackson on a bed with a girl that Hooper himself liked.
Ah, so it was a secondary, very personal betrayal that fueled his participation?
That personalized grievance is incredibly significant. It demonstrates that the plot wasn't simply Bargo dictating terms to everyone.
No, it was more like a consensus of teenagers and young adults, each with their own unique emotional calculus for wanting to harm Seath Jackson.
Exactly. And the sources even note text messages that Hooper sent to a friend where he admitted his desire to murder Jackson.
So we have Bargo as the central instigator, the shooter, driven by this misguided sense of protection. We have Amber Wright, the ex-girlfriend, who provides the mechanism for the lure.
And Kyle Hooper, the brother, driven by a deep sense of personal betrayal and jealousy.
And they brought in others. Charlie Ely, who provided the location, it was her house, and Justin Soto, who was the oldest of the youth group at 20.
The plan wasn't just premeditated, it was collaborative.
And utterly manipulative in its execution.
Yes. The execution phase began the orchestration of that lure.
Let's transition now to the actual events of that day, April 17th, 2011. Bargo gave the instructions to Amber Wright.
And the false premise was simple and, as you said, devastatingly cruel. Wright called Jackson, claiming she wanted to reconcile, that she wanted to get back together.
And Jackson, likely hoping for that reconciliation or at least some kind of closure, he fell for it.
He did. He was successfully lured to Charlie Ely's house in Summerfield. She arrived expecting a private meeting with his ex-girlfriend.
But the whole group was there.
The group of 5 youths, Bargo, Wright, Hooper, Soto, and Ely, they were all waiting for him.
And the moment Jackson arrived, the violence began. It was immediate and overwhelming.
The sources outline the stages of this vicious assault, and it suggests the attackers had no intention of simply intimidating him. The plan from the start was immediate lethal force.
The initial stage involved beating and striking him.
Right, and we know that Justin Soto, the oldest of the co-conspirators at 20, actively participated. He used an axe handle to strike Jackson during that initial ambush.
This detail emphasizes that it wasn't just Bargo. 4 individuals were physically involved in the attack before the final fatal shot was even fired.
Yes. And during this initial beating, Jackson tried desperately to save himself.
He was shot while attempting to escape the confines of the house.
That detail is so important. It shows he wasn't simply overpowered. He was actively fighting for his life when the situation became deadly.
Once he was wounded, or at least incapacitated, the group carried him back inside the house.
And the crime climaxed when Jackson was placed in a bathtub.
It was then that Bargo, the ringleader, took the final step.
He fatally shot him.
What follows it's perhaps as chilling as the murder itself. The methodical, albeit amateurish, effort to erase all the evidence.
The sources describe the body being placed into a sleeping bag and then transferred to a backyard fire pit.
They burned the body for several hours.
This multi-hour attempt at disposal speaks volumes about the group's intent to conceal the crime. This moves far beyond a spontaneous violent act.
Oh, absolutely. This is calculated destruction of forensic evidence.
And the cover-up required more help. It continued into the next morning, April 18th.
This is where the 37-year-old James Havens steps in. He was the stepfather of Amber Wright and Kyle Hooper.
And he provided the necessary logistical aid to complete the disposal of the body.
Havens' role was strictly accessory after the fact, but it was absolutely critical to their plan.
He helped the youths collect the ashes and the remnants of Seath Jackson's body placing them into 5-gallon paint cans.
And they then transported these containers to a water-filled rock quarry in Ocala, Florida, and dumped them there.
The whole cleanup effort really underscores the collective guilt of everyone involved.
And beyond just disposing of the body, the youths attempted to sanitize the crime scene itself.
Yes, using household bleach to clean the house, specifically targeting Jackson's blood in an effort to eliminate any lingering forensic evidence.
The crime was heinous, committed by a large group, and then immediately followed by this multi-day effort to conceal it.
The magnitude of it is why the subsequent legal response was so swift and so severe once the truth started to emerge.
Which happened after Jackson's mother filed a missing person report.
Exactly.
So let's pivot now to the initial legal processing of these 6 individuals. The arrests began just 3 days after the murder on April 20th, 2011.
The investigation moved very quickly to connect the 5 youths to Jackson's disappearance.
And all 5 of them, Michael Bargo, who was 18, Amber Wright, 15, Kyle Hooper, 16, Justin Soto, 20, and Charlie Ely, 18, they were all charged with first-degree murder.
In Florida, that is the most serious charge. It carries penalties of either life imprisonment without parole or the death penalty.
A grand jury indictment followed swiftly on May 4th, 2011, confirming the first-degree murder charges for all 5.
And this is a critical legal moment.
Why is that?
Because it established that the 2 minors, Hooper and Wright, would be tried as adults despite being only 16 and 15.
Meanwhile, James Havens, the 37-year-old, was the 6th suspect charged.
His specific charge was accessory to first-degree murder for his role in disposing of the body.
But his legal path was different. It encountered immediate issues.
Right. He was initially ruled mentally incompetent to stand trial back in 2014, which delayed the resolution of his case for years.
Havens eventually resolved his case through a plea deal in 2018. He pleaded guilty to the accessory charge.
And he received the maximum sentence for that specific crime, 30 years in state prison. His case, while important for resolving the involvement of all 6 parties, it remains somewhat separate from the complex constitutional issues that were facing the main 5 defendants.
So focusing now on the 5 charged with murder, the initial convictions began very quickly.
Yes, Charlie Ely was the first to face trial. She was convicted by a Marion County jury in September of 2011, just 5 months after the crime.
And she was convicted of first-degree murder. In October 2011, Circuit Judge David Eddy sentenced her to life imprisonment without the possibility of parole.
Plus a $5,000 fine. That was the maximum and, importantly, the mandatory sentence for that conviction at that time.
Next up was Justin Soto.
His case followed a different tactical path. In May of 2012, Soto pleaded guilty to first-degree murder.
This was a calculated move, right, to avoid the death penalty?
Absolutely. The prosecution was still considering it for him. By pleading guilty, he secured a mandatory sentence of life without parole, and he bypassed the risk of a capital trial.
And then in June 2012 came the joint trial of the 2 juveniles, Kyle Hooper and Amber Wright.
They were tried simultaneously, but before separate juries. Both were found guilty of first-degree murder.
Now, since Hooper was 16 and Wright was 15 at the time of the crime, they were legally ineligible for the death penalty.
Right, under prevailing constitutional standards. However, under Florida state law at the time, first-degree murder still carried that mandatory maximum sentence of life in prison without parole.
And it is right here, at their initial sentencing in August of 2012, that this case becomes a national example of evolving constitutional law.
Yes, and the inherent friction between state statutes and these huge Supreme Court mandates.
This really is the pivotal section of the legal story.
It is. On August 22, 2012, Judge Eddy sentenced both Hooper and Wright to life without parole.
He was just following the clear mandate of state law for first-degree murder.
He was. But the ground had just shifted right beneath his feet.
The timing is incredible.
It really is.
The U.S. Supreme Court had handed down a landmark ruling just 2 months earlier. In June 2012, the same month, Hooper and Wright were convicted.
And this ruling declared the mandatory imposition of life without parole sentences for minors unconstitutional.
What was the case?
That case was Miller v. Alabama. It's essential you understand the core insight of this ruling.
Okay.
The Supreme Court recognized that juvenile offenders are fundamentally different from adults. Their brains are still developing, which impacts their impulse control, their ability to assess risk, and crucially, their capacity for rehabilitation and change over time.
So, Miller v. Alabama established that a blanket, automatic sentence of life without parole for a minor, regardless of the crime, violates the Eighth Amendment.
The prohibition against cruel and unusual punishment. A judge must be given discretion to consider the defendant's youth and their potential for change as a mitigating factor.
Exactly. But here's the problem. When Judge Eddy sentenced Hooper and Wright, Florida's state law had not yet been updated to comply with the Miller ruling.
Right. The sources emphasized that there was no state law providing statutory guidelines on how to sentence juveniles for these crimes, other than the existing, rigid, first-degree murder statute.
That meant the trial judge was trapped. He was legally bound to pass the mandatory maximum sentence of life without parole.
Even though the highest court in the nation had essentially declared that very sentence unconstitutional for minors just weeks earlier.
So this immediately guaranteed they would have a successful appeal.
Without a doubt. The contrast is palpable. The severity of the crime was immense, but the constitutional protection afforded to youth was equally immense and immediate, even if the state statutes hadn't yet caught up.
This just set the stage for the legal chaos that would define the rest of their trajectories. Okay, before we track the appeals of Hooper and Wright, we need to address Michael Bargo, the ringleader and shooter, whose case proceeded on the Capitol track.
Bargo was the last of the 5 to be tried. He was convicted of first-degree murder on August 20, 2013.
And because he was 18 at the time of the crime, he was legally considered an adult. He was eligible for the death penalty.
And his role as the primary shooter and the orchestrator of the whole thing made him the focus of the state's capital prosecution efforts.
The jury returned a recommendation for the death penalty a week later, but it wasn't unanimous.
No, the vote was 10-2 in favor of death.
Then, on December 13, 2013, Judge Eddy formally sentenced Bargo to death.
And the judge's statements at the time were, well, they were highly resonant. They reflected the court's view of Bargo's culpability.
He described Jackson's murder as the most cold, calculated, and premeditated case he had seen in his entire 32 years of judicial service.
That judicial assessment confirms that even among a group of people all charged with the same crime, Bargo was considered by the court to have acted with the most significant malice and planning.
And at the time of his sentencing, he became the youngest person on Florida's death row.
So by the end of 2013, we have this very complicated picture. 2 juveniles serving life without parole under what are now unconstitutional sentences, 3 adults serving life sentences, and the ringleader on death row.
The appeals process was set to unravel almost all of these outcomes.
Almost immediately.
Let's trace how those constitutional challenges played out, beginning with the 2 juveniles, Hooper and Wright, in 2014.
In May 2014, the Florida 5th District Court of Appeal addressed the Miller v. Alabama issue head-on.
And what did they rule?
The court vacated Kyle Hooper's life sentence. It ordered that he be resentenced under new guidelines that Florida was just beginning to draft guidelines that acknowledged the possibility of parole for juveniles convicted of murder.
Amber Wright's appeal was even more dramatic.
It was. While the appellate court also recognized the unconstitutionality of her life sentence, they went a step further. They ordered a full retrial for her original conviction.
And this was due to a procedural error discovered during the appeal.
A huge one. The court found that Wright had not been properly advised of her Miranda rights by the police during her initial questioning.
The right to remain silent, the right to an attorney.
Exactly. The Miranda warning is a crucial constitutional protection. If police fail to properly advise a suspect, especially a minor, of these rights, any confession or incriminating statement they make can be suppressed.
And the conviction that relies on that statement can be invalidated.
Correct. That procedural oversight meant that even though she was factually guilty, the state had to prove its case against her all over again, this time adhering to the proper constitutional procedures.
So she went back to court.
She did. In January of 2016, a new jury found Amber Wright guilty of first-degree murder again.
So her culpability was reaffirmed?
It was, but her subsequent sentencing was now firmly under the new constitutional standards established by Miller.
And in February 2016, she received a new sentence.
Life in prison, but with the crucial allowance of the possibility of parole after 25 years.
This marked Florida's legal system finally adapting to the constitutional mandate, acknowledging her youth as a mitigating factor that prevented a permanent, irreversible sentence.
Kyle Hooper followed a similar path shortly after. His conviction stood, but his sentencing hearing was redone.
So in December 2016,
he too was sentenced to life imprisonment with the possibility of parole after 25 years. This successfully brought the sentences for both juvenile co-conspirators into constitutional compliance.
So the sentences for the 2 minors became standardized, life with a review process after 25 years. But the trajectory of one of the adult participants, Charlie Ely, who was 18 at the time, It demonstrates a different pathway to release.
One based purely on procedural mistakes unrelated to her age.
Right. Ely, if you remember, was sentenced to life without parole way back in 2011.
Her appeal didn't center on the juvenile issue. It centered on a claim of ineffective counsel during her initial trial.
This is a claim made under the Sixth Amendment, which guarantees the right to effective legal assistance.
And this kind of challenge requires the legal team to prove two things. First, that her original defense attorney's performance fell demonstrably below professional legal standards.
And
Second, that this deficient performance actually prejudiced the outcome, meaning it would have reasonably changed the verdict.
and she succeeded.
She did. In March of 2020, a U.S. District Judge, Roy B. Dalton Jr., accepted Ely's claim. He ruled that her initial conviction was fundamentally flawed due to deficient representation and ordered a retrial.
This order for a new trial, coming nearly 9 years after the murder, must have created immense risk for the state.
It did. Facing the prospect of trying to retry a complex multi-defendant case from a decade prior, the prosecution decided to negotiate a resolution instead.
And in June 2020, Charlie Eatsley accepted a plea deal.
She pleaded guilty to the lesser charge of second-degree murder. This allowed her sentence to be dropped dramatically, down to 10 years.
And because of the approximately 9 years she had already served awaiting trial and appeals, plus accumulated time for good behavior.
She was immediately released from prison right after the sentencing.
The contrast in the outcomes here is just profound.
It really is. You have Justin Soto, who pleaded guilty early to avoid the death penalty, still serving life without parole.
Hooper and Wright are serving life, but with parole eligibility after 25 years due to constitutional mandates about youth.
And then Charlie Eatsley, an adult participant, is free due to a successful procedural appeal related to the competence of her initial defense lawyer.
The role of procedure, of legal technicality and simple timing in determining the final freedom or incarceration of these defendants it's striking.
And no legal journey illustrates this instability better than the continuous capital punishment proceedings against Michael Bargo.
Right. Bargo's initial death sentence from 2013 was overturned 4 years later.
And not because of facts or age, but because of a massive shift in Florida's capital punishment law, which was itself reacting to a U.S. Supreme Court mandate.
So in June 2017, the Florida Supreme Court overturned Bargo's death sentence and ordered a resentencing trial. The reason?
Florida's death penalty statute at the time was ruled unconstitutional under a U.S. Supreme Court ruling known as Hearst v. Florida.
And what did that ruling establish?
Well, Hearst v. Florida, which was decided in 2016, it relied on an earlier precedent, a 2002 case called Ring v. Arizona. The core finding was that a jury, not a judge, must find the specific facts that qualify a defendant for the death penalty.
The aggravating factors.
Right. And they have to find them beyond a reasonable doubt. And under Florida's specific post-Hearst reforms in 2017, one of the key requirements established to comply with that constitutional mandate
Was that the jury's recommendation for death had to be unanimous?
Exactly. And Bargo's initial 2013 jury vote, we remember, was 10-2.
So under the new 2017 law, that non-unanimous vote was insufficient to impose the death penalty.
He was, therefore, saved from execution by a legislative change that happened years after his crime, based solely on the margin of his jury's decision.
So Bargo was granted a completely new penalty phase trial?
Correct. This resentencing trial began in April 2019, and the prosecution once again sought the death penalty.
And this time, the jury's deliberations satisfied the new constitutional standard.
In April 2019, the new jury unanimously recommended the death sentence for Michael Bargo.
And having satisfied that strict unanimity requirement from the 2017 law, Judge Anthony Taddy formally reinstated the death penalty in September of 2019.
Bargo's legal team subsequently pressed for further appeals.
But the Florida Supreme Court denied Bargo's second appeal on June 24, 2021. So as of 2025, he remains on death row.
He does. However, we have to place his fate in the context of the continued instability of Florida's death penalty statute, because the legal environment that reinstated his sentence, well, didn't last long either.
This is a critical footnote from the sources, isn't it? It just demonstrates how truly volatile the law has been.
It does. The unanimous requirement that saved Bargo initially and was then used to condemn him the second time was itself overturned in April of 2023.
And this was following the high-profile Parkland school shooting case.
Exactly. The Florida government once again reformed its death penalty statute. The law now permits a minimum of 8 out of 12 jurors to recommend a death sentence, reversing the unanimous requirement.
Which means Bargo's initial 10-2 jury vote from 2013, which was legally insufficient under the 2017 law,
And led to his first death sentence being overturned.
would have actually been entirely sufficient under the law that is in effect today, post-2023.
The question of whether Bargo lives or dies has depended entirely on the specific legal threshold in place at the exact moment his appeals were finalized. It illustrates a legal environment characterized by continuous reaction and reversal rather than static, predictable standards.
So this thorough review of the sources gives us a complete and often contradictory picture of the final outcomes for the participants in the murder of Seath Jackson.
To summarize those outcomes, we have Michael Bargo, the orchestrator and shooter, on death row after surviving and then succumbing to these procedural changes in capital law.
We have Justin Soto, who is serving life without parole, having pleaded guilty very early on.
Kyle Hooper and Amber Wright are both serving life sentences, but with the possibility of parole after 25 years. A direct result of the U.S. Supreme Court acknowledging the mitigating factor of their youth.
Then James Havens, the 37-year-old accessory, is serving 30 years for his role in the cover-up.
And finally, Charlie Ely, an adult participant who owned the house, is the only one who achieved release after 9 years.
And not through a challenge based on youth, but through a successful procedural appeal regarding her initial legal representation, followed by that plea deal to a lesser charge.
This examination really illustrates how a single, devastating crime can become a testing ground for evolving constitutional law.
Particularly regarding juvenile sentencing and the precise fairness parameters of the death penalty. It raises a significant question for you to consider long after our discussion ends. How should the justice system balance the undeniable, profound severity of a crime with the mitigating factors of youth and the continuous, years-long changing legal standards that govern these convictions?
That tension between delivering justice for the victim and adhering to the constitutional principle of evolving standards of decency applied to the defendant, that is what defines cases of this magnitude.
Thanks for listening.